Okay, good afternoon, everyone. Thank you for joining us today for the launch of the Innovation Law Club Africa. I can see we have some of our attendees here, and then we have wonderful speakers here with us today. So thank you for taking the time to join us. Yes, the Innovation Law Club Africa. What is innovation? I mean, to ILCA, it's the engineering of a new idea, a product, or a service. From the creation of the internet to the invention of computers, artificial intelligence, and so much more. I mean, technology continues to change the way we live, the way we work. And as I like to put it, technology is an enabler, a rescuer, and of course, the solution. I mean, case in point, the COVID-19 pandemic we're all experiencing right now. I think we can all agree we're still able to function, right? Because of technology. And as we know, the law, yes, is constantly seeking to regulate how technology is developed and how it's used. So essentially, in recognizing the need to raise a new breed of African lawyers who understand how the law is responding to the growth, challenges, and opportunities of innovation and technology, ILCA was born. ILCA is here to set the pace by enabling individuals and institutions to embrace new realities, to engage and empower lawyers and law students alike on a wide spectrum of innovation and technology law issues, to encourage professional collaboration and cooperation amongst industry, specialists, technology law specialists. And as we all know, collaboration is the future. ILCA is here to encourage interdisciplinary and scientific research that promotes innovation and technology law in Africa. And to crown it, ILCA wants to support the creation of innovation law as a specialized field of study in African faculties of law. I mean, I keep telling the ILCA team here that they should have done this when we're all back in school. But I think a short summary is to let you all know that ILCA is here to build a vibrant community of lawyers, legal scholars, law researchers, policymakers, advocates, institutions, and innovators. So ILCA is open to this entire category and various other professionals who are simply interested in capacity building, knowledge exchange, gaining a competitive advantage, and expanding their professional network within and outside Africa. ILCA as an organization is managed by a growing number of experts and industry leaders from diverse backgrounds who serve in different capacities as members of ILCA's management team, board of trustees, and advisory council. So the contact information for ILCA is being displayed as we speak. The website for ILCA, you can go to the website and you will find all of the information about the organization on there. And so please feel free to contact ILCA and find out how you can be a part of this great initiative. Innovation Law Club Africa. Thank you again for joining us all. Without further ado, I'd like to introduce you to our very, very excellent speakers for today, who are here to, tell us a little bit more about some of the things we know, a lot of the things we don't know, and of course, an opportunity for everyone here to tap into the wealth of knowledge. Our first speaker today is Meme Onwudiwe. Meme is the Executive Vice President of Legal and Business Intelligence for Evisort, the Silicon Valley startup that uses artificial intelligence algorithms to analyze and manage contracts for companies across the globe. So Meme definitely will be telling us how that came to be, right? When he's telling us today about, the artificial intelligence and the future of law. What more, Eversort, was founded right out of Harvard Innovation Lab. So Mehmet is well placed to tell us all about innovation. Our second speaker is none other than Ralph T. O'Brien. Ralph has spent decades working at the intersection of privacy, security, and risk management. Ralph is an experienced, that's what I like to call him, because he's a super experienced consultant, speaker, trainer, negotiator, and manager. And he's going to be telling us about privacy, data protection, data ethics, how, which, what is, who now. Ralph is the principal at Rainbow Consulting Limited. So he will be telling us some of those things clients typically pay him to tell them. So without further ado, I'm going to hand over to Mehmet to go right into artificial intelligence and the future of law. Mehmet, thank you again for joining us today.
Awesome. Thank you so much, Bukola, for the introduction and for providing such insight and background into this great organization that we're helping to launch today. Awesome. And so I'll go ahead and share my screen and just do a quick presentation. Honestly, what I was hoping to accomplish today, is really talk to you guys, about AI and the future of law, but really also talking about how Africa is uniquely positioned to use some of this technology to leapfrog in ways that we've seen in the mobile sector and otherwise. And so what I was hoping to do today was really set the scene by giving a little bit of background to what the current legal technology landscape looks like, dive into kind of relevant types of AI and technology there, discuss how this AI is changing the work of lawyers. And this is a presentation I've given to Fannie Mae, to BCG's legal team at conferences and symposiums. But it's really this last part here that makes me super excited to talk it with the group we have on today, which is really talking about how some of these technologies, when looking at where Africa is now, can really help move things forward. And honestly, hearing you describe kind of what's behind ILCA as an organization, I would be remiss if I didn't talk a little bit about how we started Eversort, which, as you said, we actually created while we were students at Harvard. And from that, we now have offices in Silicon Valley, New York, Canada, and clients across the globe. So I'll also in the beginning talk a little bit about that too. Great. So just to give a little bit of background on Eversort and us as a company, I joined as a first-year law student. I was only a couple months into my JD career. Where I met a couple folks at the company. I was number 5 on the team. It was lawyers from Harvard. It was data scientists from MIT. And the basic idea was, as I'm sure many of you guys who are lawyers on the line know, you go to law school, you're taught all these great ways of thinking, of imagining arguments, and then you go to a law firm and you're asked to go through thousands of documents looking for indemnification clauses, right? And the idea was, why is it that one, the experience at law school and the experience that the idea that we have of lawyers is so disaggregated from those first couple of years at a law firm? And then 2, why are we doing this work anyway? Because it's almost 2020. We know natural language processing technologies are able to do a lot of this work. And if they're going to pay us hundreds of dollars an hour to sit and do tedious tasks, there's clearly a misalignment in the market there. And so we basically, doing our law school careers, we were based out of the Harvard Innovation Lab for a lot of time, in addition to studies, and we were training AI on tens of millions of documents. And it was really just, we downloaded the whole SEC database, we got other private sources of data, and we were really working hand in hand with data scientists, because us as lawyers, of course, know the law, them as data scientists, of course, know the technology, and working hand in hand, we were able to develop technologies that when we did graduate and go out to the market, put us as an industry leader. And, even though I just graduated last year in May, just this December, we raised $15 million in a round led by Microsoft. And we're Microsoft, platinum partners. You could buy us on the Azure marketplace, and they're a customer as well. And so, which is just to say, I'm happy to take questions on this later, but, as students, I would definitely be thinking about ways to kind of come into this market and be changing things, because frankly, I mean, as a 2L, you know, in law school, I was talking to general counsel daily who were asking me questions about how they use technology in their processes. So even though law is typically hierarchical, it's a very much of a field where you have to wait your turn. I think that we are uniquely positioned right now where younger lawyers can actually bring highly valuable ideas and skill sets to law firms and other places, because the technology landscape is just changing that quickly. Without further ado, let's look at how quickly the technology landscape is changing. Legal tech is completely different now than even when it was in 2016 when we first started. And when we first went out looking for funding, a lot of what we heard from venture capitalists were, you know, lawyers are always doing the same things. You know, you're not going to get a lawyer to stop using Word or to start using these technologies. They're very risk averse. I mean, if you even look at this graph here in 2016, 2017, 2018, legal tech has completely exploded as an industry. I mean, that's also, if you look recently, DocuSign buying Seal. Even through this spite of current economic downturn, I think legal tech is one place where you're still seeing lots of investment. And it's because if you look here, even JP Morgan internally has built out technologies, you know, automating away kind of what lawyers are doing. And there's a thought that, you know, even though law has been a field that seems to have been outside of the innovations and changes in technology, that things are finally coming home to roost, and that people are finally, you know, understanding what's going on. And I think something I've seen is, you know, even through this downturn, for us, we've actually seen more engagement from potential clients, and that's because I think this kind of crisis shows exactly why you need to be a company that's leveraging technology. I mean, for example, we had like a company that's one of the largest retailers in the United States as a customer, and they, you know, they no longer they're no longer really getting income, right? Because no one's going to stores. And there's a clause in their contracts and their leases called the co-tenancy clause, which basically says, hey, in the event that the foot traffic slows in malls, your rent will decrease. And so they need to find that clause in all of their hundreds of thousands of contracts, leases with malls, right? And if you're relying on manual systems, that you're just not going to be able to move at the speed that, you know, business requires these days. And so I think that's just one use case of why, even through times like this, I think people are seeing technologies in legal tech as essential. And just to further frame today's conversation, as I leave more describing the landscape to actually the technologies themselves, we're going to focus on really AI technology, right? So not collaboration tools like Google Drive or e-signature, even kind of contract generation, which might look like AI. I'm not going to go and give a whole treatise on everything. We're not going to talk about RPA versus machine learning versus neural networks. We're going to try to be very focused today, okay, on just so we can get a base level of understanding from a technology perspective that allows us to really dive in. And I'll even jump into, okay, great. Actually, it looks like it was the wrong screen. Okay, cool. So diving forward, what I really want to focus on today from an AI technology perspective is 1, computer vision, 2, classification, and 3, extraction. And I understand that not all of us here are technologists, not all of us here are lawyers, so I'm going to start very base. It's also good to understand that, you know, these aren't all kind of, this is an exhaustive list. You know, computer vision is a type of technology, while classification, extraction are more applications of, you know, AI technology. But once again, I want to be really focused on use cases here because just to kind of build from a knowledge perspective. And so computer vision, that's really looking at images to draw conclusions. So basically AI analysis of images. And so that's things from self-driving cars to kind of optical character recognition. Classification, that's really breaking data into different classes based off of AI analysis. It's really, when you talk about AI being a way of structuring unstructured data, this is really a good way of thinking about that, where you have a mess of documents, you have a mess of things, it's able to put it into like buckets. And lastly, extraction, which is, I think, especially from an AI perspective in law, is something that gets people very excited because that's going into documents, going into things and pulling out key information automatically without having to leverage manual processes to do so. Great. And so starting with computer vision, driverless cars are a very good example of this, right? And if you think about what's going on, it's really computer vision at its core is using AI to analyze images, right? So here you see kind of, this is an example from Tesla, right? How there's a camera on top of these cars. And what that camera is doing is every millisecond, right? It's taking those images and it's processing them to actually understand what's around it. And it's using that information to direct its action, right? And if you wonder about how do you train things like this, if you guys are familiar, for example, with CAPTCHA, right? Every time you need to prove you're not a robot and you have to click at the signs or the streets and cars on the road, you're actually playing your part in training AI, because it's you're teaching that AI kind of what is a car and what is not a car and things like that. And so you guys are a part of that. And you guys might be wondering, why are we looking at driverless cars? This is about law. And the reason is, another prime example of computer vision is optical character recognition, right? And optical character recognition is the ability to take scanned documents, kind of paper files, and turn them into digitized documents where you can control F, run searches, and do things like that. And so it's actually the same core technology that's behind self-driving cars. And you've also trained this through CAPTCHA. So if you know in the past, when maybe to prove you're not a robot, you see kind of hand-drawn letters, and then you have to type what they actually say. That's another example of you actually training AI in your everyday life, which of course is coming back for this kind of scanning. And so at a high level, looking at computer vision on documents allows you to take kind of paper files and make them digital so you can run searches. But at deeper levels, you can also do it to do things like maintain tables, maintain the formatting of documents, right? Bolding, italicizing, right? And that kind of information, like whether or not something's bold or underlined, can be important to preserve for if you do want later down the line, your AI to be able to pull out clauses, to pull out key information, having some of those clues like, hey, this was in bold, hey, this is italicized, and preserving that information can be very important. And especially when looking a bit down the line towards how these technologies can really help enable and push things forward on the African continent. I think that in Africa, you see a lot of businesses and governments still doing things from a paper-based perspective, not fully digitizing. And so these kinds of technologies can really help you, go from a paper-based state to a more flexible digitized state. And so this is just a high-level overview on computer vision. It's a very flexible technology, as you see, in between kind of cars and contracts. Great. Moving to classification. And this is one that, if you see here, there's a lot of dogs and there's a lot of muffins, right? And as you can see, the muffins look pretty similar to the dogs in some cases, right? And the question is, how do you teach AI to know what's a muffin and what's a dog, right? And the way to do that is just to give it some examples of muffins, give it some examples of dogs, tell it, hey, this one's a muffin, this one's a dog. And if you're going to use neural networks, which is a type of machine learning algorithm that's unsupervised, so you're not going to kind of give it more clues, you'll leave it for the AI to give distinctions, right? So perhaps, you see 4 dots on this one and 3 dots on this one. This one was tagged as a muffin. Maybe it tells you as an AI, hey, if I see more than 3 dots, it's probably a muffin, not a dog, right? Or maybe it's little teeth or something like that, for example. But this is just to say that really at its core, from a classification perspective, you show kind of this technology AI different examples of a tagged data set, right? A data set where you've very clearly said this equals X and this equals Y over massive amounts. And then you run it through the AI so that when it comes against new data, right? New information that it hasn't seen before, it can leverage what it's seen in its past to identify it moving forward, which frankly isn't very different than what we do as humans, right? It's our experiences looking at dogs and looking at muffins historically over our lifetimes that leads us to quickly know which one of these are muffins and which ones of these are dogs. And so it's not incredibly different from an AI perspective. Of course, when you're doing this with contracts or with agreements, there's going to be simple ways, right? Maybe you just want to look at the title of the agreement. Does at the top, does it say confidentiality agreement, right? But what if it says mutual non-disclosure agreement and non-disclosure agreement? Those three are all the same, but they have different things at the top. And so just from an AI perspective, it can get complex. But the basic idea of having classes of information and teaching the AI over massive amounts of tagged data to be able to classify those moving forward remains the same. Awesome. And then next up is extraction. As a company, this is something that we get pulled into a lot, right? But it's really about the key information and pulling that out effectively. And so, of course, one, you have to define what information you're looking for, right? Do we want to pull out effective dates? Are there particular clauses that you want to find out? Maybe you want to pull out the party names, right? Extraction is also interesting because there could be levels of summarization. So for example, if someone wants you to pull out the governing law, do you want to pull out that full text saying, hey, this, shall be governed in accordance with the laws and statutes of blank? Or do you just want to pull out, the location of United Kingdom, right? It's a question of kind of how you want to pull out this information, whether or not all of its data or just a small part of it. But this classification is really done by tagging massive amounts of data. But now it's at a niche level, right? They're not just saying, hey, this whole document equals this. You're saying within this document, here's the title, here's kind of the address, here's this other information. And then by showing this to the AI so many times, and there's different ways of doing AI, you can do neural networks, you can do kind of different types of technologies. But at a broad level, by introducing this massive amounts of tag data, you're able to train the AI. So when it comes against new data, it's able to perform these processes similarly. I would be remiss, there are, I guess, if people want to go into this in the questions, there are big differences between supervised and unsupervised training algorithms, which can have derivative effects on kind of extraction and classification. And so that can be something that we can talk about down the line. But overall, I really just want to give a broad view of some of these AI technologies. Great. And so in looking at how this is changing the work of lawyers, let's look at just an example, right, of what a lawyer typically does. Obviously from a due diligence perspective of, hey, we're selling this company, find all the change of control provisions, obviously just the data extraction there is going to be able to automate that process. But when we look at a more complex process, right, for maybe identifying risk inside of contracts, a way that you can take some of what I've shown so far and use it in a process would be here where you upload a document. You as a company probably have your own internal playbooks, right? Hey, we want our governing law to be in these 5 states. Maybe we need a cap of liability that's 2x, nothing high, or a cap at this particular amount. And so what you can then do is you can, of course, use these AI techniques we've talked about in the past to extract this data, but then you can run a layer on top of it to determine whether or not the data that's extracted actually adheres with the playbooks that, that have been provided by a customer. And what that allows you to then do is take a document that's third party, completely non-standard, but then run through that document and look for the ideas that symbolize risk as defined by your playbook, which will then help the lawyers, instead of having to read those hundreds of pages looking for risk, it can help direct them to where potential areas of risk are so they can remediate them quickly and effectively. And so we work a lot with companies who think about this, yes, from a legal perspective, but also from a process perspective. Because every extra day that you're reviewing an NDA means you're not engaging in business with this company and your deal velocity is going down. And so this actually has very key revenue. This actually has very important revenue impacts. And you'll find a lot of our customers like, Brooks Brothers and Cox Automotive are actually working with their procurement teams almost more than their legal teams. Because I think that, being lawyers, we sometimes think so contracts are for lawyers. But at the end of the day, these contracts are really most important to the business people at companies. The reason they sit with lawyers is because we can understand them, but we're not really the ones, frankly, using them, even from a law firm perspective, where we're reading other people's contracts, right? Great. And so I think this really highlights this really highlights a lot of kind of what I wanted to talk about just from a technology perspective. Really, what I want to spend these last 5 or so minutes is really looking at kind of how this technology that I've described thus far can provide a lot of value in an African context. And I think that if you take a step back and look at kind of our current era, right? I think it's very fair to say that we live in an era of data, where data is becoming more and more important. We're understanding more and more its value. We're understanding more and more how we've given all of it up without even actually knowing, about the privacy implications about the world we've constructed. But data really is power. And I think you see today that data is a place where Africa fully lags behind. I think you'll find a lot of cases, people researching things about Africa in Africa will look at the CIA World Factbook to get facts about their own countries in some cases, just because the availability of data is so low sometimes on the continent. And I think a lot of that is because, when we're talking about the manual processes of storing things, and I've worked at ILCA, I've worked at at a few places on the continent as well. And you do see a lot of information is being stored on paper, which isn't terrible. And I know that there's many processes for digitization today. But when I look at modern day processes towards digitalization of documents, at offices on the continent, it strikes me as almost as if African countries in the 90s were rushing towards landline phones, right? Because why are you rushing towards landline phones when, mobile centers exist, right? And so if you actually look at it, the technology that I've been explaining today is very top of the line. I mean, we built our platform based off papers being written at MIT in 2016, right? But at a broad level, a lot of what I've shown is pretty accessible. And at a broad level, it's actually not being leveraged by companies in the West. And you might be wondering, with all of this AI technology, why wouldn't a company in the US and Europe, want to kind of go all in to track massive amounts of data in its kind of written documents? And the reason is that in the same way as kind of phone technology, the West has gone very step by step, right? So if you think about it, they had kind of they had like paper folders, right? Paper files, and then they digitized them, right? But what's a digitized folder if not just another folder, structure just on a computer, right? If you want to find that paragraph in that contract, you still need to know the right folder, the right subfolder, what page of the document it's in, and then where inside that document's in before you can actually assess that data as a lawyer, right? And so it's really just replicating a physical folder structure on a computer, as opposed to really democratizing the data inside of it. If you think about Google, you don't need to know exactly the websites and the subdomain and the subdomain to find that particular thing you're looking for. You just need to ask it, hey, where is this? All the data of the internet's already been structured by Google, which is the beauty of Google, it's just structuring data, right? And then you can take that structured data to run a query across everything, right? And so to get back to the analogy of the West, of course, started with digitizing, and then now they're stuck at a place where you have, once you kind of scan a document into a system, you have a human manually type that stuff you want to track, right? So now if you want to see all the contracts expiring in the next 6 months, you'll run a report based off of the manually entered data into like an iManage, right? Or maybe every time someone uploads a document, they say it expires on this date. And because they type that in at that point, you can now run a report across that data. And so that's the current state of play in most Western countries where they're leveraging data extraction, but it's manually typed. And if it's manually typed data, then because you're leveraging humans to type it, you're necessarily going to only ask them to keep track of the most important information, right? And then it comes down to how do you define what's the most important information? And it's going to be short-term thinking. If you think about it, most people wouldn't call a force majeure clause the most important clause in their contract. Most people just skip past force majeure clauses. And I think as all of us lawyers on the line now know, those are pretty important with COVID, right? You know, now you want to be able to run a report to say, show me every force majeure clause I've ever signed that refers to pandemic or quarantine. And if you haven't been copy pasting every single force majeure clause that you've signed in the past 10 years, then you can't run that report automatically, right? And so there's a lot of gaps in manually tracking information. And the fact that, you know, the African continent is beginning to engage in processes to take, you know, this paper data and digitize it by kind of scanning it via PDF. I think that if you just added to that layer, just a soft layer of data extraction, right? Where just the basic data structuring is being done, you would then have African companies, African countries, African governments who actually have levels of data insight and data mining into what they're actually doing higher than Western companies and Western countries who've had digitized documents for decades, but are still stuck in manually entering information because frankly, the added benefit from going from manually entered information to AI is maybe only such just because you can only really envision that much. So they might be more hesitant. While if you're going from paper to digital, it doesn't probably add a crazy amount just to do a little bit of that level of extraction. And so that's something that, especially with the inspiring words of Bukola in the beginning about how this is really about creation, this is really about innovation. I do think that there's a broad opportunity here from an African perspective, you know, to take some of these technologies and actually to be at the front of the game when it comes to having data and having information. And I think it's something that I hope more people would discuss. And I've discussed on places like, you know, channels and here now, but I'm really excited to have a deep conversation at the end of this. And so, yeah, thanks so much for taking time to walk a little bit through the legal tech industry, AI, and law with me, and very excited to hear people's thoughts as we move to the Q&A section later.
Thank you so much, Meme. I personally found that very interesting. And I'm sure Ralph will be telling me how to protect myself. I mean, from you AI people, now you're using us, and for every verification we do, right? You're training your AI. So, I mean, humans should get paid at some point, I reckon, right? Okay, thank you very much, Meme. I think that was very insightful. For questions that you have for Meme, we have our Q&A session right after Ralph has spoken. And for those that are just joining us, thank you again for joining us. It's the launch of the Innovation Law Club Africa. As I've said to the entire, to the people here earlier, ILCA is building a vibrant community of lawyers, legal scholars, law researchers, policy and advocates, innovators. And the entire idea, right, is to encourage professional collaboration and cooperation amongst technology law specialists and encourage interdisciplinary and scientific research that promotes innovation law in Africa. So everything Meme has been telling us is quite interesting. And I mean, who knows, maybe there is free trials for the AI. Meme will tell us later. I think that's a question I have. And it would save all of us some time, of course, right? From pouring to all of those documents when we're doing due diligence, and then we avoid spending long weekends at the offices and, late nights. So thank you very much, Meme. And of course, I will introduce you again to our second speaker, Ralph T. O'Brien. He will be talking to us about privacy, data protection, data ethics, how, which, what is, who now. Ralph is the principal at Rainbow Consulting Limited. Ralph, thank you again. I do hope you enjoy the artificial intelligence, bit from Meme. So over to you, and share some of what you know with us.
Well, thank you very much, Pacola, and thank you very much, Meme. I did very much enjoy the AI presentation. It's very interesting. You talk about AI putting people into classes, you know, machine learning, putting people into buckets and using to differentiate legal behaviors between one class as another. I think in the civil rights movement, we'd call that discrimination.
I would agree.
I just think just throwing that out there for a moment. No. I'm actually very supportive as privacy, not as a win or lose topic, but actually as a positive sum, as a win-win, where we can use technology and privacy law in order to achieve the maximum benefit for society. So I'm just pulling your leg and being slightly combative. So let me display my screen as well. I'm going to be talking a little bit about what will be essentially the last 70 years of privacy innovation, the last 70 years of privacy law across the globe in about 20 minutes. Brave or what? I am Ralph O'Brien. I'm not going to delve too much into my introduction, but my personal goal essentially is to make what is essentially a complex legal experience, complex laws, case law standards accessible, make organizations be able to actually understand and innovate going forwards using privacy as an ally. And so the important thing to know about me is not all this boring text on the screen. I deliberately filled it all up with rubbish. The important things to know about me is I'm based in Europe, and I am a strong Europhile, so I apologise to the Brexit contingent of the UK. I'm based in rural England, and I'm a massive geek. So if you want to not talk to me about anything that involves privacy law, and you'd rather talk to me about Star Wars, Dungeons and Dragons, rolling dice, or painting plastic miniatures, or the superpowers of the latest Doctor Who, I am more than happy. But my real passion in life is privacy. My real passion in life is privacy, and it's to actually help the human condition going forwards in this age of data, this age of technology. Now, I'm going to talk to you a little bit about the last 70 years. I'm going to start with privacy. I'm going to sort of career into how privacy evolved into data protection laws and whether the concept is even the same, and sort of finish off talking about data ethics, a nebulous concept that we kind of hear people talking about, but not really practicing. So I'm just going to start talking about privacy as a human right. And not to be too depressing, privacy has been around as a concept since the 1600s, 1700s, but I suppose looking at it in modern law, it really cropped up in Europe, certainly in the 1950s. But that was as an aftermath of the Second World War. You know, for the first time, really in European history, certainly, we'd finally realized what it meant for the human condition to be treated differently by virtue of our skin color, to be treated differently by virtue of our religion, to be treated differently by virtue of being put on a list. And really, we looked at, in the Second World War, what happens if someone was essentially given a number and stamped with that number on the basis of their religion or ethnicity, you know, and quite literally sent off to concentration camps, gassed, treated very differently as a sector of the human race, as a class of the human race. And really, after the Second World War, we developed something called the Council of Europe. And the Council of Europe was 47 member states that said, well, never again. And it was only the Council of Europe and later the United Nations that decided to come up with the ECHR, the European Convention of Human Rights, and the Universal Declaration of Human Rights. So really it was 49, 50, sort of finally in the 53, before we had human rights as a sort of a concept. And to me, privacy is the essence of human rights. It's the essence of freedom. To me, privacy is about innovation, creativity, safety. It's enable societal prosperity. If we don't have freedom of our own thought, places to go, to gather ourselves and to be able to think, well, we're never going to innovate anything. if we're never going to be able to hold some sort of level of secrets, well, from the wider populace, well, we're never going to be able to hide. We're never going to be able to, in the modern terminology, we kind of think of sharing as a good thing, hiding as a bad thing. But, you know, certainly I deal with people across the world where the laws of those countries may indeed invoke criminality by perhaps the nature of their gender, or the nature or their gender that they want to be, or perhaps the nature of their sexuality or sexual practices. And for those people, especially those vulnerable people, those people who might have protected characteristics, it really does mean that civil liberties becomes a very important part of their life. And so privacy and human rights is really a concept that's evolved from the 50s, you know, through to the 80s. And in the 80s, in fact, the Council of Europe and the OECD, that is the Organization for Economic Cooperation and Development, came up with what we call a set of principles as computers are being developed. And they recognized very early the power of computing. They recognized very early that computers were going to be something that was going to change the playing field. Much the same as a stick does not contain as much destructive powder as a gun, and a gun does not contain as much destructive powder as an atomic bomb. You know, we've really seen that growth in technology. Now, you could argue that a sword or a stick or a bomb or a gun are good things, you know, because they keep the peace. But equally, anything that's good for great good could be used for great ill. You know, technology is essentially morally and ethically neutral. And so when we have to, you know, establish new technology, we always have to establish laws and rules that will enable that technology to be used responsibly. And really, that's what privacy is for me. It's not about saying no to things. It's about putting in the right safeguards to make sure that people are not disadvantaged by the use of that new technology. So we've got nations signing up to the Convention of Human Rights and Convention 108. And that to me is fascinating. Really, we're talking about the individual versus the state. And when I think about privacy, I think about the secrecy of the individual, the power balance between the state and the citizen, the needs of the many compared to the needs of the one. We only have to look recently in the COVID situation to see that our individual liberties might be being curtailed by the power of the government, you know, in order to serve a greater good. In order to serve a greater good. You know, you could grant the police extra powers. You could put a contract tracing app on somebody's phone. You could tell them to stay indoors. You could monitor where they go with surveillance, with drones. All of these things reduce our civil liberties in society and increase the government's powers. To me, what becomes very interesting is, when do the government put aside those powers? What happens with the data that's being collected? Is it going to be retained afterwards? What other purposes could that then be used for? How then is that going to shape and impact our society going forwards? Because once you have power, it's not easy to put it down. It's not easy to drop it. Privacy to me is a Pandora's box. Once something is known, it cannot be unknown. Once something has been collected, well, it becomes very hard to delete it, very hard to get rid of it, and very easy to say, oh, we'll just use it for that, or we'll just extend the powers for this. And to me, this sort of balance between individual liberty and equality and justice against the power of a state is really where the right, the human right to privacy really comes in. And we've seen that in Africa. Whilst we've seen sort of the UN and the European Convention on Human Rights happen in sort of the 50s and 60s, in Africa, we saw the African Union step in the 2000s with the Malabo Convention, the Malabo Convention that really looked at cybersecurity and personal data protection, and across the 50-odd African nations to really look at that sort of human rights-based approach. And that's very interesting because not all the world shares a human rights-based approach to data. Certainly in Europe, because of the legacy of the Second World War, we have that human rights, fundamental human rights approach to privacy. And again, that's translated into a lot of Africa. A lot of the African nation states are obviously heavily influenced by European parliamentary systems, either Francophile or Anglophile nations especially. And therefore that influence has translated that human rights-based approach. And I've had it put to me I've done a load of work for the African Digital Rights Hub recently in Ghana. A lot of those people talk about the fact of not wanting to lose the fourth industrial revolution, not want to enter into a digital form of slavery. And to me, that becomes really important when you look at human rights as a basic necessity of dignity of the individual. When we talk about AI, and we talk about AI being 99.9999% accurate, well, that's great. But with a large enough sample size, that still means that there's a significant proportion of individuals whose rights are going to be interfered with, who is going to be discriminated against. And we can really introduce bias from the previous data or in the way we release this technology that we really do have to be careful of in our nation state versus citizen war. But it's not human rights across the rest of the globe. In some other parts of the globe, Russia, China, North Korea, it's not fair to say they don't have privacy laws. It's just fair to say that the privacy laws heavily favor the state. The state takes the power, and the state's power against the citizen is absolute. And then again, we see different models in the USA, and it's worth mentioning the USA because obviously we get a lot of our technology stack from the USA. We've inherited our technology stack from, Meme speaking today from Silicon Valley. And therefore, Silicon Valley very heavily, your Microsofts and your Apples and your Googles and your Facebooks and your Twitters of the world come from a US and a US legal frame point where privacy has not been so much a state of mind based on human rights, but one of consumer protection. It's a be nice to your customer law. Be nice to your customer. And this is very different from the human rights-based law. A human rights-based law almost starts from the basis of you can't hold data unless you have a good reason why. Whereas the US almost looks at it from a very basic state as you can do what you like with the data unless the consumer can think with a good reason why not. And they're two very different starting points, two extremely different starting points. But when we get a lot of our tech from sort of US large global conglomerate corporations, that's a real sort of stretching point as the US organizations reach out across the globe into Africa and into Europe, where the legal situation and the legal starting point is a vastly different one when it comes to privacy. So that's privacy, the needs of the many compared to the needs of the one, the idea of secrecy. And really that's developed over the years into data protection, and I'm going to call it data protection as opposed to privacy. Yes, I believe the two things are different. And often I kind of see that in articles. People talk about privacy quite a lot. They say, oh, privacy won't let us do that, or privacy will stop us from doing this. And that's a very naive way of looking at things. We don't live in a binary world. It's not a yes or no answer. It's often how much. What is the risk? Clearly we cannot live in a private world. We can't live with 100% privacy. We interact with people socially. We sign up for bank accounts. The government needs data in order to tax us. The police needs data in order to be able to police us effectively. There has to be a balancing act. It's not a binary. It's not a 1 or a 0. Privacy is different for different people with different risk appetites in different situations. How you feel about your sexuality and how much you broadcast that is going to be vastly different from how much you broadcast your credit card numbers, or vastly different from how you broadcast your email addresses, or vastly different from what I'm doing now, broadcasting my image and my rather parochial views around the internet. And so for me, data protection then becomes important. It's not about privacy. Forget about privacy. Data protection law is the thing that affords us the balance, the thing that enables a law that doesn't say yes or no, but enables us to justify why we have the data, that tells us what safeguards we put in place if we are privileged enough to be the custodians of that data. So data protection law for me is really not privacy. Privacy is about our right to secrecy. Data protection law for me is then about how organizations treat the data that they then are given the safeguard for. So let's have a look at data protection law. Now, leaving the Council of Europe behind and through the 80s, we started to see a rise of national laws. The 1980 OECD guidelines, the 1981 Convention 108, countries signed up to it and developed national laws. In the UK, our first data protection law was 1984. And the fundamental principles haven't changed since. The fundamental principles of having a lawful basis to process data, making sure data are accurate, making sure that we get rid of data that we no longer need it. We keep it, with appropriate levels of security, and we keep it for one or more specified purposes and not for other purposes. All of these principles have been around since 1980. They're not new. They're 40 years old. And we can see the same principles in that 1980 OECD document as we do now into the future. Really in Europe, I suppose Directive 95/46 EC, that's known as the Data Protection Directive in Europe, was the major big change. And what that did is it required every European member state, to the 27 of them, or probably 26 and a half at this precise moment, I should say, speaking from London. But the 27 European member states had to create a data protection law which answered that European directive. But not all of them were the same. Even though they had to comply with the spirit, the principle of the directive, there were still 27 national laws and 27 national regulators. And each of those laws had different fining powers. For example, in Ireland, you had to go to court to get a fine. In the UK, the regulator could give you a fine, an administrative penalty, but that penalty was very, very low. In some countries, they would do it per offence. In Germany, they mandated you had to have data protection officers. In the UK, there was no such thing legally. So even though it made us pass data protection laws, it varied. And this is how I see Africa today. This is how I see Africa today. We're seeing a lot of what I call 95 directive laws passed. When I look at the laws of Nigeria, Kenya, Ghana, for example, we're seeing a lot of the laws that seem to comply with almost that 95 directive approach. The principles are there, the governance is there. However, some of them are establishing regulators. Some countries have got different levels and fining penalties. Enforcement varies tremendously depending on which nation state you might rely upon. And some, of course, have no privacy law yet at all. So I think really interesting talking about Africa as a unified African Union of 50-odd member states. We see a very tremendous change across the continent. And we're even seeing some now moving to what I'd call the more GDPR, the more 2000s style laws. Mauritius, good example. Mauritius, good example there. Okay. So, of course, here we're not talking about obligations placed on countries. Now the focus has changed. Now the obligation is not on the country, it's on the organization or data controllers, as we now know them. Really sort of interesting change. We're not talking about individual versus state. We're now talking about individuals' rights versus corporation obligations versus organizational obligations. Big change in data protection law as opposed to privacy acts that come out of these international obligations. We do see those principles, the OECD principles: accuracy, retention limitation, collection limitation, purpose limitation. And again, I've got to say, because they're based on those sort of European principles, we're now seeing, as we're going through the 90s, this presumption against processing. You can't do it unless you have a legal basis. And indeed, if you're going to process sensitive data, special category data, data such as health and children's data, or trade union or religion or ethnicity, you might even need additional legal mandates, legal justifications in order to have that special protected data. So that was the 80s and 90s. Now moving forward into the 2000s and into the 2010s. I'm not going to say to anyone about my taste in music, by the way, that you'll see on the right-hand side. In the 20s and the 2010s, we realized that the data protection laws we had in 95, they weren't enough. And we developed what we call lex specialis, specialist laws that really looked at the internet, really looked at cookies, really looked at direct marketing. And we called this in Europe the e-privacy directive. And that developed a load of more national laws about what we call privacy in electronic communications, email marketing, cookies that might be placed on your computer to track you around the internet as the advertising and marketing surveillance capitalism mechanism of the internet began to grow. And we saw this increasing tracking of individuals, the monetization of data, and again, national laws which had massive variance. If you go to a French website and a UK website, you'll see their cookie banners are different. Their definitions of what forms are required and necessary, a marketing and advertising cookie are different. Very, very interesting sort of laws, very interesting sort of change. And then finally, in the 2010s, we now saw in 2016, the GDPR. Everyone knows the GDPR, the General Data Protection Regulation, and it's had a huge global influence. And the reason why is for the first time, we brought in this idea of extraterritorial extent. You know, it doesn't matter if you're not in Europe. It doesn't matter if you're not in Europe. The idea is if you are targeting people who are in Europe, or even if you're in a European country, a European organization that has data subjects in other countries, they are now covered by the GDPR. So we've got this idea of this sort of territorial scope creep. And for the first time, I actually stopped working with European countries for the last 5 or 6 years. I've stopped working with European organizations. And as a European data protection professional, my main client base has been Asian, African, and American organizations. Organizations that, even though they're not in Europe, are then subject to the GDPR, are then targeting European data subjects. And for the first time, having to upgrade their levels of privacy thought, you know, having missed the 80s, 90s, and 2000s to this GDPR level of looking at data. The idea, of course, was to try and fix that national variance across Europe, that the regulation is a stronger thing than a directive. Therefore, every country's law had to look roughly similar. But we're still seeing variance. You know, we're still seeing, especially in enforcement, we're still seeing German and Austrian regulators really, really being tough on enforcement. Whereas, how should I put it, the English, the ICO, the Irish DPC, we're seeing a little bit more, how should we say, business-friendly activity. Especially, it's been a criticism held of the Irish DPC that obviously its national economy is based on having Google and Facebook and Microsoft at its main European headquarters. So you know, whether or not there's been political interference in the regulatory landscape, I'll leave that to your imagination. But now we're going away from just having organizations having to comply with these principles and moving in towards what we call accountability, records keeping, the ability to demonstrate compliance, not just managing personal data, but having a management system that overarches personal data. Much as we saw in information security, things like SOC 2, ISO 20001, management system standards that require the management to interface and partake and proactively set rules and monitor, and then be able to look at how the organization is handling, get the right statistics and KPIs, and then invest resources in improving. This is where we really saw the GDPR look for this word that they call accountability. And also, interesting enough, was these extra rules on data processors. The old original data protection directives of the 80s and the 90s, they really looked at data controllers. They said, these companies that take your data and are in charge of your data. But now we're seeing, actually, even when they're outsourcing, they no longer do the data processing themselves. They now hand it over to your Googles and your Microsofts, your Facebooks and your Salesforces and your Amazons, the larger companies. And really, under law, the data controller should go to this tiny little data processor and say, do what we tell you. You know, it's our rules. We're the company. We've got a contract with you. Do what we say. Has anyone ever tried to go to Microsoft or Google or Amazon and say, can we negotiate your contract? Will you do what we say? Unlikely. And therefore, the GDPR really increases obligations away from just data controllers, but onto data processors, the service providers, the people who will just say, hey, under contract, all we do is process the data on your behalf. But actually, they've probably got more power over the data than you do. Do you know where your data is? Where is it in these big cloud data centers? Really interesting stuff. And this is where we are. But actually, on the back end of that, we've seen regulatory overload. We've seen paralysis within the regulators. For the first time, we're now seeing and we're now learning that companies that these laws are based upon are bigger than countries. A Microsoft, a Google, a Facebook, it probably has more money to spend trying to defeat or affect the legislative landscape. A good example of this would be the new e-privacy regulation in Europe. These US companies are spending millions and millions and millions of pounds on to try and defeat in law, to try and stop the new regulation from coming into play. And really, we're now seeing for the first time that countries are smaller than companies. They may try trying to assert their national law upon these huge global companies. And these global companies saying, no way, you're a very small company. My gross national income is bigger than yours is. I'll do what I like. I'll release one version of my app across the globe. If you want to find me, find me. If you want to take me to court, fine. I've got more money to spend than your regulator has. And that's a really interesting position. That's a really interesting position. And what we're now seeing actually is the regulator beginning to stall. The regulator beginning to be overwhelmed with individuals' requests, be able to not keep up with the funding of these large companies. And what that has actually resulted in is private actions, pressure groups, complainants being taken by law firms, what we would call a class action in the US, where individuals affected by a data breach, frustrated with the ability of the regulator to interfere, are now grouping together and asking law firms to take their cases to the courts as a collective or a class action. We're beginning to see that even overtake the concern of these companies. They almost don't care about the regulators. They're now really focused on, private actions that can be brought against them by large law firms. Really interesting situation. And so you could argue the law has failed. You could argue that these large companies are more worried about scientifically whether they can do something, because the regulator isn't going to stop them when they do. And by the time it's done, it's too late. A good example might be Cambridge Analytica. Yeah. We've looked at perhaps the Brexit situation, the Trump situation, electoral interference via social media, allegations that people are harvesting data and using that to deliver micro-targeted advertisements to try and change your political view. Subtle psychological manipulation, information warfare, if you like, taken from the military, using data harvesting to predict your personality and your hopes and fears and dreams, and being able to push specific targeted information at you to try and change your views and voting habits, or even not to vote if you happen to be trying to target the opposition voters, for example. We've seen a lot of cases of that. And what happened with the regulators in Cambridge Analytica? They disappear, they shut up shop, they start a new company. Find me, fine. I'll disappear and I'll come back somewhere else. So if the law has failed, what hope do we have for the future? And to me, that finally lies in data ethics. So forget about privacy, the state versus the individual. Forget about data protection as the law versus a company, and start thinking about data ethics. Who do we want to be? Don't be evil. What is good and what is bad? And what are we as a company going to use? And to me, the 2020s and above is going to be about data ethics. And data ethics is not the same as the law. Very important thing. Throughout history, I think we can all pinpoint times where things were legal that were not ethical. Tax evasion schemes might be an interesting one. Racial segregation, perhaps chemical castration of homosexuals, all things that were legal. Yeah, we only have to look at our heroes in society, people like Rosa Parks and Nelson Mandela and Alan Turing, for myself. People who stood up against the law, who broke the law, rule breakers, because the law was not right. Ethically, it was wrong, in their view. So to me, the answer is not organizations doing this because the law tells them they have to, but organizations having to make fundamental choices about corporate responsibility and who they want to be. What sort of corporate behavior do I want as my management team? And is my customer base going to notice that? Is my customer base going to come to me because I'm cheap? Is my customer base going to come to me because I'm good? Is my customer base going to come to me because I protect them? Or is my customer base going to come to me because I exploit them? And to me, we're actually seeing this now. We're seeing larger organizations seeing privacy as a competitive differentiator, seeing data protection not as something that's bad. I mean, looking back to those principles, data accuracy, why would we want to hold inaccurate data? Data security, why would we want to throw our data all over the place? Yeah. Data minimization, why would we want to hold on to out-of-date, excessive, irrelevant data? Privacy principles to me are not bad things. They're win-win. They're good corporate practice. That's all they are. Good information management tools, you know, and information is going to be our lifeblood. As we said, we live in the age of data. This is not a zero-sum activity. It's a win-win. It's a positive sum activity. And that's really what it becomes for me, a positive sum approach to information governance. And so now what we're seeing here, we're seeing actually a little bit of a fall in the legalese. And I hate to say to this to my lawyers around the room, but the worst person to write a privacy notice is your company lawyer. I hate to say it, because they will program it in legalese. Privacy notices and transparency statements aren't contracts. You don't read them and accept anything. You are just telling people what you do with their data. It's about transparency. So why would you hide that? Why would you get a lawyer to write it? You know, I'll tell you who I get to proofread my privacy notices when I write them for companies, my 8-year-old son. If he can't understand them, there are adults out there with a literacy age beneath him. So to me, succinct notices written in ways that we can understand. The rise of impact assessments. What is the impact of this to the individual? Should we do it rather than can we do it? Who will this discriminate against? How can we safeguard against that? How can we protect our customer and put the customer at the heart of who we are? Things like ethics board, your privacy by design. Yeah, it's hard to change something once you've created it. Get the privacy guys involved. It's what I used to call the Friday afternoon situation. I'd sit at my desk on a Friday afternoon and I'd have individuals come to me and say, hey, we're about to launch this. We thought we'd look at it. It launches in an hour. And I'd have to say no. I don't want to be the evil data protection officer saying no. I want to say yes. Get me involved at the start. I can add value. I can help you to say yes. And we now start to see companies do this. People like DuckDuckGo, new search engines, Brave, you know, that now looks at new browsers, mail companies, Facebook having to reassure their customers with advertising campaigns that they're doing things right. Probably the king of this, I'd guess, is Apple. Apple's marketing campaigns center around privacy. You know, for them, I went to E3, the big entertainment show in Vegas. Apple didn't have a stand there. They painted the side of a hotel with what happens on your iPhone stays on your iPhone. They weren't competing over the fact they had the better megapixel camera. They were competing over the fact that they safeguard their customer base. We've even seen it across Africa. Guinness is a really interesting one. Guinness is a really interesting one for me. And I often think of people like organizations. I'm quite a fan of a Nigerian Guinness myself. And I actually, and I won't talk about who makes the best fufu either. But to me, the most interesting thing for me is really about responsibility and taking responsibility. So for me, going forwards, I'm going to say what these alcohol companies say. Because to me, data is a drug that we've been imbuing as an organization. It's not the new oil. You can't replicate oil. You can't copy oil. You can't disadvantage an individual's human rights with oil. Data is not the new oil. Data is more than that. It's people's hopes and dreams. It is people's health. It is people's race. It is people's human dignity. It is the essence of who we are as human beings. Therefore, the future, we're going to have to do what drink companies do. They always say, please drink responsibly. We're going to have to do what gambling companies do, who say, please, please gamble responsibly. So I'll leave you with this. Going forwards, whether you're talking about privacy, data protection, or data ethics, please, please, please manage personal data responsibly. Thank you.
I told you all you were going to enjoy that session. Thank you, Ralph. That was really good. Data indeed is power. I think there are a number of people who have questions for you both in the Q&A box. So I'm going to go to that shortly. And I particularly found it interesting, you know, the point about, you know, regulators not being able to, you know, compete, you know, with the funding, you know, from these companies. And it's real, you know, and especially as I think we know that they do a whole lot, you know, with the data, you know. So it's quite all very interesting. So thank you again, Ralph. So I'm just going to dive right into information warfare in the Q&A data room. And so the first question we have, I think we have one to Ralph. Okay. So it says, if the global approach to privacy is this fragmented, can we say that the concept of privacy is a human right is realizable?
That's a fascinating question, and probably one I haven't got enough time to answer. That's a whole nother presentation in itself. It is fragmented. There is no doubt about it. You know, the US come at it from a place of consumer rights. Africa and Europe come from a place of human rights. Elsewhere on the globe, there are people look at it as a states' right. So we may as well try and solve hunger and poverty at the same time, right? To me, we're seeing growing pressure in the US for it to be considered as a human right. They're talking about new privacy laws, privacy regulators. COVID is going to change the world. There is no doubt about that. But to me, I think it's realizable. It's definitely realizable. And how it is realizable is by companies realizing that data protection law is not some external stimuli. It's not a trap or a trick or something out there that is there to hurt you, something you need to comply to, yes or no. To me, it's about fundamentally using that as a competitive differentiator, actually establishing it ethically as part of your brand and part of your ways that you protect individuals, rather than as a legal responsibility, as a fundamental part of who you are as a business.
Thank you. Meme, I think a number of the questions for you really have to do with trying to find out if we're going to get some, as we call it, expo by you giving us, your slides. I think we'd all like that. I think the second part is maybe we want free trials as well. So I think we can tell them some of the slides will be shared after the session. So definitely for those asking, the slides will be made available to you. And once I have a free trial from Meme, and then I can talk to you about how to come on board. So we can take that from there. There's another question. Super, thank you, Meme. Okay, so there's a question for Ralph, and I was hoping you will spend some time to talk about this. And, how does, Africa move forward, right, together? When its laws are different, right? Is privacy and security the same thing? I mean, we touched on the GDPR. It's 2 years old, right? What's changed in the world as a result?
Okay, that's about 4 different questions. Okay,
Yeah.
okay, sorry. The GDPR is not 2 years old; it's 4 years old. It was a 2016 invention.
Okay.
It was enforceable from 2018, so that's where the 2 years comes from. We are coming up on its 2 years anniversary, 25th of May, of course. I mean, you could argue that it's failed for a regulatory approach, but I actually think what it has done is it's increased visibility. I mean, 20 years ago, when I said I worked in data protection, nobody knew what it meant. They could pretty much just about understand security. If I said information security, they'd ask me to fix their computer. So it has increased transparency. It's increased people's understanding of their rights, and it's increased organizations' understanding that at least they've got an obligation. Whether they've embraced it as a compliance headache or as something of benefit to them is another matter, but I certainly think that that's increased. Looking at the African question, yes, you're right. Africa all has different laws. Some parts of Africa don't have any laws. Enforcement is sporadic at best. It depends where you are, definitely. It is almost a lottery depending on what part of the continent you happen to be in and what your national law may be. But I think if Africa wants to compete on a global stage, if they don't want to enter into a digital slavery, wants to be able to attract business from elsewhere, there's almost no choice. You've got to have comparable levels of protection in order to attract that international trade and investment and to make other countries feel like it's a safe place to do business.
Okay, so it's interesting you mentioned enforcement, right? I mean, there's a question here which says, how can privacy issues be resolved using alternative dispute resolution?
Well, there's another good question. Yeah, I mean, traditionally, we've seen 2 main routes, I guess. One is through the regulator, the other is through legal action and the national courts. I would say the third route possibly is with individuals, companies themselves who have managed to do things correctly before it's got to that state. The one thing I would say is the regulator or the law firm that you got, that someone complains to, will always ask, well, what did you do? You know, have you come directly to me, or have you raised it with the company? And actually, one of the things I think of, you can actually get away with quite a lot as a business by just treating your customer nicely, by saying to your customer, by dealing with their complaint and handling it and treating their data in the way they'd expect. So to me, when we're looking at layers of defense, you know, forget alternative dispute resolution, because the company themselves should have the chance to be able to solve that before it ever goes. So internal legal counsel is certainly going to have a role to play there. In making sure that it never goes to the regulator, it never goes to the courts, because you've managed to solve the issue between you and the customer in the first place.
And of course, once we start treating data responsibly, we may not get there. Yeah.
Yes, of course, the first line of defense right there. Yeah.
Absolutely. Meme, Essay wants to know if AI is teachable. Can it be used unsupervised to represent clients in court? How does that play out? I mean, I'm not a litigator myself, but I'd like to know how that will play out.
Yeah, I mean, it's a very interesting question. Actually, just this last week, I was talking with a friend here who's actually in the California Bar Association, and he told me that they just agreed in their last meeting to actually allow automated systems to practice law and give legal advice if it goes through some level of vetting. So just from a practical perspective, is this allowed? I think the answer is that growingly, yes, you will be able to provide automated legal services and give legal advice through automated uses. If you're going to look at using it to actually represent you in court, right? That's a bit of a leap, right? For having a robot lawyer doing that. I think it's what I was saying before. I don't think that AI is going to replace lawyers. I don't. All of my, everyone I went to law school with, was yelling at me, saying I'm taking their jobs, all this stuff.
Anyway.
Yeah, exactly. I don't think you'll have automated lawyers. I think particular processes that today we see within the legal realm will be automated, right? So I think due diligence. I think maybe even to an extent, some case research, so I guess a good way of answering this would to kind of tell you what I've seen through kind of working in legal tech industries and seeing other folks. I've seen many folks, developing systems which actually review litigations to actually create a numerical value on how likely those litigations are to win. And then actually, they go to investors then who actually would then be investing in litigations because they're paying to kind of, fund those and then take the expected returns, right? And so I think from the perspective of determining how likely cases are to win, to building evidence from an e-discovery perspective, which is already kind of a long-standing use case for AI in law, and just kind of searching and building evidence, I think so. I think there can be more in actually being able to use AI to understand case facts and link them to relative, case patterns and case fact patterns to kind of build that kind of, cases. But for an automated system to go through the process of, first of all, being a human, you need to build business, right? You need to be a business development if you're kind of a partner, right? So to reach out to people, to hear their needs, to understand the problem, to kind of go to the direct resources, I think that'll take a long time. But I think human and AI enhanced working together, I think will happen more. And there's actually a law firm called Atrium out here in Silicon Valley, which recently went under, which is unfortunate, but they were that first one to be like, hey, this isn't just a law firm of humans. This is a law firm where every human is being AI enabled. We're not going to do billing by the hour. There's going to be flat fees for services because we're using the highest levels of technology. And although that, unfortunately, just about a month or so ago, did go under, I think that strategy of having technology deeply embedded and almost having a cyborg lawyer, you could call it, instead of a robot lawyer, I think we'll be seeing a lot more of that.
Thank you very much. That's Very interesting with the law firm. But I mean, we won't go into what happened. So I will go to the next question. And that's for you as well, Meme. It says, considering what we've heard about data ethics, I like this one. What practices have been adopted in AI development to build data ethics? This is against the backdrop that training AI systems requires humongous amounts of data. So tell us how AI is being responsible.
Yeah. I mean, so AI is very broad here, right? And so I think there's a lot of, I think when you look at issues with, ethics and data sets and AI, a lot of times that's in realms of, almost, being able to, situations where you're predicting human action, right? So predicting who's going to commit crimes, predicting, kind of where incidents are going to occur based off past data, because it kind of builds in, it basically builds in biases. And so I think the best way of doing that, of course, is to provide diverse data sets. If we would have built our platform, so I don't think it's going to have, from our perspective, it's not going to have ethical issues. It's going to have almost business issues, because if we were to train all of our data off of only the SEC database, for example, then it might have issues, because that's only with kind of, that's only the most public large companies. When it sees contracts of kind of maybe a smaller mom and pop shop, it might not be able to kind of analyze that well, because it's used to kind of only these huge, massive, corporate documents and things like that. And so I think at a high level, you need to have diversity in data sets. I think this is why you see things like, human face recognition, performing much lower on folks of African American descent and on folks with darker skin tones, because the training data set that was used to train those technologies in the first place did not have, significant enough sample sets there. So I think in all AI training, at the end of the day, it's all about the base data. So you really have to make sure that you're training your systems on a representative form of base data, so that you don't have issues either from an ethical perspective or just a practical perspective.
Bias in AI is really interesting, actually. I'm looking at Boston. They released an app to fix potholes in the road. Mm-hmm. And they only released it on the Apple Store. They only released it on the Apple Store, not the Google Android platform. And what they found is they were starting to fix roads in more affluent areas of town, because the higher paid people tend to have Apple products and the lower paid people tended to have Android products. Oh. So really interesting, it just the data destroying. We've also seen really interesting ones, like in Germany, people putting mobile phones in little carts and walking around the streets in order to create virtual traffic jams on Google Maps.
Amazing. Wow, thank you, Ralph. That's interesting. And thank you so much, Meme. I think, and of course, to our attendees, it's been very, very interesting. I personally found this very educating and enriching, right? And of course, to everyone listening and watching, there's broad opportunities in artificial intelligence. So look into that. And of course, you can find Meme on LinkedIn or any of the social media platforms. And of course, Ralph, thank you. Data is power. And I think even personally, I'm going to start gathering data now, a whole lot of data. So thank you very much. A big thank you to our attendees again for joining us, for being a part of this. Please look out for future initiatives from the Innovation Law Club. Visit the website, it's live now, and feel free to join, be a member, participate, join us, and let us, develop innovation and technology law, and see how, we can balance things and solve this problem around, the regulators suffering from funding. So I think by the time we all collaborate and participate, we will be able to make things better for everyone on, either end of the spectrum. So thank you. It's been a wonderful day. And of course, we look forward to having you again on future seminars hosted by the ILCA. All right, then, that's it for this afternoon. Bye, everyone.
See you.